All right. Well, the general requirements, I won't read the rules. The rule, of course, is 60Q 6.115 that we're going to be dealing with today. The one thing that I wanted to touch bases on, there's really nothing new in this topic, I don't think, but the same issues, I think, seem to come up year after year. One of the things that I see in my office is that we get a lot of phone calls for things, of people asking us to do things. According to the rules, any relief which you seek must be done by motion in writing and filed. So we get a lot of phone calls about setting conferences or setting hearings or, just different procedural kind of matters in cases. And of course, every time the response is always the same, that we need to, that you need to file the motion on it. I think the one catch that I see where motions seem to fail mostly is the personally conferred with. The rules require that you personally confer and you put the certification in the motion, or it's denied automatically. What I see, not more frequently than you would expect, not in every motion, but I see pretty regularly I'm denying motions because people are not putting the certification in there and they're not contacting. I think the biggest issue I've seen with this, and I don't know if you are seeing the same thing, is I will see that we emailed opposing party on February 21st, and then the motion's filed at 9 a.m. or 10 a.m. February 21st. It's like, well, how much time of response did you give them? So on those ones, I've been denying some of those when I see that they're filed on the same day the contact is, especially if it's first thing in the morning. You've given a person an hour, and I don't know if you're seeing those sort of same things. I've actually seen them where people put the time in that they contacted the opposing party at 9:08 a.m. and then they filed their motion at 9:15. So there's 7 minutes response time, and it meets the letter of the law and the rule, but I don't think it meets the spirit of the rule. Personally conferred with, I suggest and always hope that people would call. I know that's not the world we live in today. Everybody wants to text and email, but I can't tell you the number of cases I've seen. If I see a motion that I think the party should have worked out, I'll set it for hearing. They'll come in, and I never say a word. They come in, they talk about it, they get it worked out. And so in that case, if you'd have just picked up the phone, it probably would have saved everybody a lot of time and effort. I don't know, are you saying the same thing?
Yeah, and you try not to, as a judge, let anyone hold a motion hostage by playing ostrich and not responding. If you're making those attempts and your opposing counsel just isn't responding, you could list your good faith efforts and maybe the dates. Some people have attached emails. As a practitioner, I would occasionally attempt to just pick up the phone or have my assistant pick up the phone and set a 5-minute phone conference with opposing counsel so we'd have the time on the calendar. Now, sometimes we do that and they wouldn't show up for the phone conference, but that's your good faith effort. So just outline those efforts in your motion to let us know you're trying the best you can. I appreciate that if you've got a motion and it's time sensitive and the other side just isn't responding, sometimes you got to file that motion. I think that's where being able to outline all the good faith efforts you've made is helpful.
Yeah, basically the same thing. Just make your effort. A lot of times, well, not a lot of times, I have seen sometimes the certificate of service just doesn't say at all whether the other side is contacted. Those are almost always going to be denied. So like my fellow judges, just try to do that extra effort. And I know it can be frustrating, but we understand that. And at some point, we know you got to file, but at least give us something to show that you made an attempt.
Yeah. And once filed, the rules do allow to enter an order on it. And that's people get. I mean, you get anxious, and I understand that. The rules say that we can hold the motion for 15 days to wait for the response, and then enter the order, or we can just enter the order. But if it's time sensitive, what happens if you enter the order, then you have to give the other party or anybody 10 days to object to the order if you've entered it within the 15 days. Well, especially if they're time sensitive, what I find a lot of times is, well, if I enter your order now, by the time the 10 days goes past, whatever your pressing issue is going to have been passed long ago. So, but we often get, even on non-time sensitives, we get contacted from practitioners, asking, well, we filed a motion a week ago and there's not an order on it. Why don't we have an order on it? Well, we're holding it for 15 days for the response. So I will sometimes grant a motion, or not grant it, but rule on a motion. Usually it's if I look at it and based upon the face of the motion, I'm going to deny it. I'll deny it within the 10 days. figuring the other side's not going to object if I enter an order within 10 days and it goes in their favor. But it is important to remember that there is that 15-day waiting period, and sometimes it's just, by the time I enter an order and wait and give them 10 days to respond, we're not going to accomplish what you want to accomplish within the time frame as well. So that's always something to keep in mind, because we get a lot of calls about people being anxious for orders on motions.
Yeah, and please help us out on if you've got some urgency. We know when the mediation is, because that's on the court calendar. We know when the final hearing is, because that's on the court calendar. But say you've got a motion to compel discovery, and you got a doctor depot coming up in 10 days, and you want that discovery before the doctor depot, put that in the motion, because then it'll get sort of pressed to the front. You could call it an emergency motion. I'm a bit reluctant to recommend that, because some attorneys, I think, have learned that if they throw emergency in front of every motion, that trying to get pushed to the head of the line. Don't be the little boy that cried wolf. I mean, if you got a true emergency, it probably is helpful to title an emergency motion, because that will catch our eye. But then in the body of the motion, please include what emergency or relevant event you have that we need to try to make sure we either have a hearing on or rule on the motion before that date.
I would just add that I'm not adverse, I don't know about you guys, but I'm not adverse if you want to have your assistant call. You file your motion, it is urgent, it's okay. Just have them call and say, you know what, I know that we're within the 15 days, can we go ahead and set a hearing? And almost invariably, I don't know about you guys, but we'll allow a hearing to be set. And it could maybe be set within a few days. And so whatever is of an emergent nature, I think it's fine to have your assistant call.
That being said, though, don't create emergencies unnecessarily. If you get a notice of taking deposition of your client on January 1 and it's set for February 28th, don't wait till February 27 to file that motion for protective order, because then it's very difficult for us. One, either we rule on it without hearing from the other side, or even if we try to set a hearing, it's hard to get everybody, especially if it's filed on a Friday and the depot's at 9 a.m. on Monday, to even set a hearing at that point. It's somewhat troublesome or difficult.
Yeah, I mean, I think we're all cognizant, that emergencies, although I think there's technically a specific definition of emergency, and that, we have this deposition coming up isn't technically an emergency, but I understand when you put the title on it, that's, you want to draw our attention to it, and we will deal it. I will set hearings on things. And that is really kind of the good way to do it, and you can file. I like everything to be in writing. I'm very anal retentive when it comes to sort of things like that, because when I want to look back on a case, in Lakeland, cases stay around for decades. Literally, I can't tell you the number of 1980s and 90s dates of accident that I have. So when I look back at this case from 20 years ago, it's helpful to know exactly what happened. So I like things to be filed so that I can look at a docket and know, well, this motion was filed, there was a request for a hearing on it, we set for hearing, So I'm probably a little more of a stickler on that than just taking phone calls to set hearings. But yeah, if there is a time sensitive, then call or file some sort of a request for a hearing so that we can get it on the docket and get it talked about and heard through a hearing if need be, if we don't have the time to wait the 10 days or the 15 days as is required by the rule. So.